Hello everyone, I'm Jed Rubenfeld and this is Straight Down the Middle. Well, a little different background today. I'm coming to you live, okay, not live, but I'm coming to you from my wife Amy Chua's parents' house in Berkeley, California, where we are celebrating Amy's dad's 89th birthday. So, happy birthday, Leon. But wouldn't you know, the Supreme Court chooses yesterday to hand down a blockbuster opinion. Its decision in the Birthright Citizenship case, Trump versus CASA. So I got to break down that case for you. Now, here's the first thing you got to know about that case. Even though it was the court's famous birthright citizenship case, the court did not decide anything about birthright citizenship. Instead, the 6 justices who formed the majority, and they were the 6 conservative justices, they took on another different, very controversial issue, namely the issue of nationwide injunctions. And they slammed the brakes on those injunctions, that powerful but controversial tool of the judiciary. Well, shortly after the decision came down, President Trump called a press conference and hailed the decision as a monumental victory for the Constitution. By contrast, the dissenters in CASA, the dissenters had a little bit of a different view. They said that majority ruling was an existential threat to the rule of law. So, what exactly are nationwide injunctions? What did the justices say about them? And is this case a victory for the Constitution or a threat to the rule of law? Let's get started. All right, a nationwide injunction. What is that? Well, to put it simply, a nationwide injunction is an order from a court that says to the federal government, you can't do this anymore. It orders the government to stop doing something. That's it. That's what a nationwide injunction is. Well, wait a minute. Why is that so darn controversial? Well, look, normally in court, the judge can issue a ruling binding the parties who are in the case before him. The judge can issue a remedy for the parties in the case before him. But he can't go out further and issue an order that binds non-parties. Look, if Peter sues Mary saying, you didn't pay me for some work I did in your house, the judge can order Mary to pay Peter, but normally the judge would not and could not order Mary to pay a bunch of other people, even if there was evidence in the case that indicated that she'd stiffed other contractors too. Just can't do that. Can't order her to pay other people who aren't before the court. You know, maybe there's different facts. They got to bring their own case. Maybe she's got a defense against them. Maybe there's other facts. Anyway, just can't do it. Okay. Now, what happens when a district court can issue a nationwide injunction like that? Let me step back a second. Nationwide injunctions are very different from that. In a nationwide injunction, the court says to the federal government, you can't do something to anybody anywhere in the country. That's a very different thing. The district court is purporting to order the federal government in its conduct all over the country with respect to everybody who's subject to the applicable law or executive order, not just with respect to the parties before the court. That's quite unusual. We didn't have any nationwide injunctions in this country, according to most people, until 1963. And they have a very interesting, powerful, controversial effect. Nationwide injunctions allow a single district judge, in essence, to govern the whole country. Well, that can be a problem, because what you can get is forum shopping. Smart lawyers, they'll go find a favorable judge, they'll bring a case having to do with some new executive order, and they'll ask that judge to enjoin it. And even if other judges around the country are taking a different view, if they can get one judge to say no to that executive order, they can block that executive order for the whole country. Well, these nationwide injunctions have just exploded in the last 20 years. According to one count, there was only about 27 issued in the entire 20th century. That's right, 27 for the entire 20th century. But against Trump alone, there have now been over 100. Okay, so this is a big deal. But it isn't just Trump who has had this kind of problem. Presidents from both parties have also had nationwide injunctions issued against them. under Democratic administrations, lawyers would go running to judges in Texas, federal courts in Texas, to try to get nationwide injunctions. And they had success doing that. They blocked immigration policies from both Obama and Biden, getting nationwide injunctions to do that. Nowadays, the lawyers are running to Massachusetts and Washington to get their nationwide injunctions, and they're having a lot of success getting them against Trump. Well, what happened was you had staggeringly partisan results. I can't emphasize this enough. So according to a Harvard Law Review count, of the 64 nationwide injunctions issued against Trump in his first term, 59 of them, 59 out of 64, were issued by judges appointed by Democratic presidents. Similarly, of the 14 that had been issued against Biden, counted by the Harvard Law Review, all of them, every single one, was issued by a judge appointed by a Republican president. Those are staggeringly partisan results. And the Supreme Court yesterday, in this case, CASA, the Supreme Court put a stop to that practice, or tried to. The court said, no. Federal courts do not have the power to issue injunctions for parties that apply to parties not before them. They can issue the injunction for the parties in the case before them, but that's as far as they can go. So what does that mean? The majority in yesterday's ruling is not saying that district courts cannot rule on and find unconstitutional an executive order. So let's take the order that was at issue in this case. In CASA, 3 district courts had held that Trump's Birthright Citizenship executive order was unconstitutional. And they had purported to issue orders governing the whole country. Under the Supreme Court's ruling from yesterday, those courts can still rule on Trump's Birthright Citizenship executive order, but they can only do so for the parties before them. So if a plaintiff comes in and says, my child was just born, and they were born here in the United States, and they are a U.S. citizen under the Constitution, but Trump is denying them their papers, they're not going to get a Social Security number, they're not going to be able to get a passport, they have a right to that. A judge in that case can say, you're right, I find the order unconstitutional, and your child is entitled to a Social Security card, to papers, eventually to passport. They are a citizen. But what the court cannot do is say, and the federal government must do likewise all over the country. The federal government must stop enforcing this order with respect to anyone, anywhere in the country. So that's what the Supreme Court has done. Lower courts can still issue orders for the parties before them, but they can't go beyond that. They can't purport to govern the whole country. All right, now, is this ruling, as Justice Jackson put it, an existential threat to the rule of law? I don't think so. Look, as I said before, most people agree that we didn't have even a single nationwide injunction in this country, at least in its contemporary form, until 1963. So I don't see how it can be an existential threat to the rule of law to say, look, judges can no longer do something that nobody had ever done for the first 175 years or so of the nation's history. Second, this case is being presented as some kind of, crazy hyper-partisan ruling. It's really not. For years, lawyers and judges on both sides of the aisle have been objecting to nationwide injunctions. It's true, only the 6 conservative justices joined yesterday's opinion in Trump versus CASA. But it was Justice Elena Kagan, one of the court's liberals, who said in a 2022 interview that it just can't be right for us that a single judge can stop a nationwide policy in its tracks. And in 2024, the Biden administration filed a brief in the Supreme Court taking basically the same position that the Trump administration just took. That is, objecting to nationwide injunctions on the ground that they were inconsistent with traditional equitable principles that said judges can only rule for the parties in their case, and objecting that nationwide injunctions give individual single district court judges too much power. So it's not really a partisan case, hyper-partisan case, in my opinion, and it's certainly not an existential threat to the rule of law. I'll tell you what really divided the majority from the dissent. It's simple. It was the merits of the case, the constitutionality of Trump's birthright citizenship order. The majority, the 6-justice majority, they steadfastly refused to reach that question. They didn't say a word about whether they thought it was constitutional, unconstitutional, but the dissenters, the 3 dissenters, they sure did. They reached that question, and they forcefully argued in defense of the principle of birthright citizenship, and they said they excoriated Trump and the administration for violating that principle. In their view, the majority's opinion was, in essence, allowing the Trump administration to go on violating the constitutional rights of hundreds of thousands or millions of kids all over the country who are not yet parties to an ongoing suit. Okay, so those are the basics of the case. Now you know the basic issues. I've walked you through it. Now I'm going to express my opinion about it. Did the court get it right? Did they get it wrong? Well, as I think you can tell from what I've said to you so far, I believe there are very serious problems with nationwide injunctions. I think it's a good thing that the court put the brakes on them. But I don't think the court quite got it right. And let me quickly tell you why I think so. I think the majority opinion, oddly, both went too far and not far enough. What do I mean by that? Well, the majority took this historical approach to deciding the question. The majority said this case is governed by a 1789 statute, and under that statute, federal courts only have the same powers when they issue injunctions that the High Court of Chancery in England had in the late 18th century. Now, the Constitution doesn't mandate that kind of approach to this case, but that's the approach the conservative justices took. They like historical approaches. That's the approach they took, and they couldn't find any analog to nationwide injunctions in 18th century English chancery practice, so they said federal courts don't have the power to do that. Well, there's an interesting implication of that way of looking at it. Under the majority's opinion, no federal court has the power to issue a nationwide injunction, not even the United States Supreme Court itself. I'm going to repeat that. Under the majority's opinion, even the United States Supreme Court can't issue a nationwide injunction. Well, that ruling was not necessary to this case, and in my opinion, it's a bad one. That's the sense in which the court went too far. The United States Supreme Court has always had and should have the power to strike down a law or an executive order in its entirety and to say that law, that executive order, that's just straight up unconstitutional. It's unconstitutional in its entirety. Now, when the Supreme Court issues a ruling like that, that's got to mean that the federal government cannot keep enforcing that law or that executive order because it's unconstitutional for them to do so. They can't keep enforcing and acting on an unconstitutional law or an unconstitutional executive order. So the Supreme Court, in a case like that, it's got to be able to issue a nationwide injunction. It would be nuts, it would be absurd if after an opinion like that, the government could keep doing the same unconstitutional thing to each new person, hundreds of thousands of people, and each one of them had to bring their own suit, millions of suits, to replicate the same result, to obtain the exact same remedy. That would be absurd if millions of individual cases had to be brought to reach the same result after the Supreme Court had ruled. So again, that's a sense in which the majority ruling went too far. But at the same time, the majority's 18th century approach to this left open major procedural loopholes under which district courts can continue to issue nationwide injunctions, even if under slightly different names. Justice Kavanaugh was very clear and picked up on this in his concurrence. One of those loopholes is a class action. As Justice Kavanaugh pointed out in his concurrence, well, all a plaintiff needs to do to get what's essentially the functional equivalent of a nationwide injunction is to change his suit, his lawsuit against the government from an individual suit to a class action suit. And guess what? Right on cue, this morning, this very morning, the plaintiffs in Trump versus CASA, they filed an amended complaint, changing their lawsuit from an individual plaintiff's lawsuit to a class action. And it looks like, at least in principle, under the majority's ruling yesterday in Trump versus CASA, these district courts can now issue the very same nationwide injunctions that they did before, but now under the rubric, under the procedural device of a class action. Well, that's a problem, because if that's true, then we haven't done anything to deal with the problem of forum shopping and the other problems I was mentioning to you before. Now, we don't know if that maneuver is going to work, but based on what the majority said in its opinion, based on everything they said, there's no clear reason why it can't work. So to me, that's a real problem. Now, both of these flaws, the fact that the court went too far and the fact that the court didn't go far enough, they have their source in one thing, and that thing is this 18th century approach to the case that the court took. That 18th century approach meant that the court wasn't focusing on the real problems of nationwide injunctions and the problems that they've been causing since over the last 20 years. I'll repeat what that problem is again. It's not complicated. Nationwide injunctions allow a single forum-shopped district court judge to basically govern the whole country. That's the problem. That's a district court problem, not a Supreme Court problem. It's a problem with letting district courts issue nationwide injunctions. It's not a problem with letting the Supreme Court issue a nationwide injunction. The court, in the CASA case, the majority, the Supreme Court, could have reaffirmed the power of the Supreme Court to issue a nationwide injunction while imposing tight restrictions, preventing district courts from doing the same thing. In my opinion, that's what it should have done, but instead, it did the opposite. It announced that even the Supreme Court can't issue a nationwide injunction. It prevented the Supreme Court itself from issuing a nationwide injunction while issuing an opinion that allows district courts to keep issuing nationwide injunctions under slightly different procedural rubrics. So, bottom line, according to straight down the middle, Trump versus CASA, it's not a threat, an existential threat to the rule of law. It's not a threat to the rule of law at all. It's not even a hyper-partisan case. But is it a solution to the problem of nationwide injunctions? I'm concerned that it may not be an effective, satisfying, enduring solution. Okay, that's it from now for me. That's it from me for now. I'll be doing more episodes on other of the recent Supreme Court opinions. Bye for now.